Imagine you're standing in a courtroom. Two sides are presenting completely conflicting stories. How do courts actually decide what to believe and what to ignore in a trial? They can't just guess. Instead, they rely on a strict statutory framework that filters reality before it ever enters the record.
To understand how this works, we have to look closely at the precise rules that govern every single evidentiary inquiry here in Pakistan.
We're going to trace the logical flow of a trial. We'll start with the Qanun-e-Shahadat Order 1984 framework, move through relevancy, admissibility, and weight, examine the burden of proof alongside legal presumptions, and finally arrive at proof beyond a reasonable doubt. Let's start with the foundational structure of the Qanun-e-Shahadat Order, or QSO, 1984. Promulgated as a presidential ordinance, the QSO replaced the Indian Evidence Act of 1872. The most significant departure is the incorporation of Islamic evidentiary principles. For example, Article 17 requires specific Muslim male witnesses of good character for certain had offenses. Article 24 also raises the bar for confessions. However, for civil and non-had criminal cases, the QSO preserves most of the general 1872 framework.
The order contains 166 articles, organized into three parts that perfectly mirror the logical sequence of an evidentiary inquiry. Part 1 is relevancy, determining what facts may actually be proved. Part 2 covers proof, detailing how those relevant facts are proved. And Part 3 covers the production and effect of evidence, including documentary evidence, witnesses, and the burden of proof.
Now, let's explore the three distinct pillars: relevancy, admissibility, and weight. The first gateway is relevancy. A fact is relevant if it's connected to the facts in issue in a logical manner, making them more or less probable. Think of motive or preparation. But crucially, if a fact isn't relevant, it is entirely excluded from evidence. If it survives that test, it faces admissibility. These rules may exclude even a perfectly relevant fact. A confession could be highly relevant, but Article 38 strictly bars confessions obtained by threat or promise. Similarly, Article 26 outright excludes confessions made to police officers. The final pillar is weight. Once evidence is legally admissible, the court uses its discretion to assess how much credence to give it. A corroborated eyewitness account obviously carries much more weight than an uncorroborated statement from an interested party. This brings us to a vital distinction anchored by the Supreme Court in Altaf Hussain v. the State. The court ruled admissibility and weight are entirely separate. You cannot exclude evidence at the admissibility stage just because it seems incredible. Incredible evidence might be technically admissible. Its lack of credibility simply affects its weight. Moving to Section 4, the burden of proof. Who actually has to prove the case? Under Article 117, the prosecution has the absolute burden of proving every element of an offense. But Article 121 introduces an exception for special knowledge. When a fact is especially within someone's knowledge, the burden of proving it falls upon them. For instance, explaining the possession of recently stolen property. But we must be precise here, as the Supreme Court clarified in Muzaffar Ali v. the State, while Article 111 requires the accused to provide an explanation, the ultimate burden of proving guilt never shifts. The prosecution must still prove the main issue of guilt. Let's move on to Section 5, legal and factual presumptions under Article 129. The statute sets out two categories. Mandatory presumptions, where the law says the court shall presume, mean the court must accept a fact as proved until it's disproved. Then we have discretionary presumptions, where the court may presume and actually choose to draw an inference. A really critical discretionary presumption is Article 129G. It states that the court may presume that evidence which could be given but is actively withheld would be unfavorable to the person withholding it. Applying this in criminal trials requires extreme care. In Muhammad Nawaz v. the State, it was established that drawing this presumption against an accused person violates their right to silence. So Article 129G primarily operates against the prosecution. If the state deliberately withholds evidence, the court can presume it favored the defense.
This brings us to our final section, the standard of beyond a reasonable doubt.
Inherited from common law, this is the ultimate standard for a criminal conviction. It's not a mathematical certainty, but rather the certainty of an honest, reasonable person. Crucially, a doubt must be based on reason and specific evidence, excluding purely speculative or fanciful doubts. The Supreme Court solidified this in Mian Muhammad Nawaz Sharif v. the State. The court ruled the benefit of the doubt must be based on reasonable grounds emerging directly from the evidence.
A defense counsel can't simply invent a doubt without evidentiary foundation and expect an acquittal.
Mastering this structured inquiry, from relevancy through admissibility and weight to the exacting standard of proof beyond a reasonable doubt, is the very foundation of truth in the courtroom. For lawyers, students, and litigants, understanding this framework is critical because a case is only ever as strong as the evidence the law actually allows you to prove.